Good morning. Welcome to session 3 of chapter 2 of company law. Here we are going to study about the effects of pre-incorporation contracts. The important feature of separate legal entities is that after the incorporation of a company can enter into contracts with third parties in a separate dignity. It will get a separate dignity as company. So this provision is given by Companies Act of 2013 also, and company will be different from its members. While talking about this, obviously one question arises in our mind that what might be the story of pre-incorporation periods? What might be the situation? What might be the respect or what might be the dignity of a company during pre-incorporation period or before the establishment of a company? Is the company permitted to enter into contracts with the third parties? This is the obvious question arising in our mind. See, a group of individuals who plan to establish a company, who plan to incorporate a company, in their own dignities they can enter into contracts, but not in the name of a company. Because company would not get any physical existence, right? Company is not getting physical existence during pre-incorporation period. So company yet to get physical existence. Therefore, during pre-incorporation period means before the establishment of company, if it is in the conceptual stage, it cannot enter into, it is barred from entering into contracts with the third parties. So here, now we are discussing the story of pre-incorporation period or pre-registration period. Here, incorporation stage is a stage where the company is registered with the registrar of companies. Of course, it is quite compulsory for every corporate unit to get registered with the registrar of companies, and it is one of the means to fulfill the requirements laid down in law, Companies Act. Here, this is the second stage in the formation of a company. Registration of company is the second stage. First one is establishing the conceptual formation of a company, and second one is registration stage. So, under this stage, the company transfers its existence from virtual to real. So, physical existence of company can be seen. Later words. Here, the promoters or the persons who are contributing for the establishment of company, persons who are associated with the company for any lawful purpose may form a company, getting it registered with the registrar of companies. So here, as I said just now, we are discussing about pre-incorporation contracts. So we can study the registration of companies or incorporation of companies later. Before the incorporation of company, is it eligible? Is it permissible for the companies to enter into contracts with the third parties? If you think so, these points are available to you. So the three restricting points are: first one, not binding on company. Here, what are the effects of pre-incorporation contracts? That is the obvious question coming to our mind. As an answer to that, the first effect is not binding on the company. Not binding on the company means company is not eligible to enter into contracts, because before the incorporation of a company we can't see the physical existence itself. So only virtual existence can be seen. Means the formation of company will be there in the minds of people, promoters only. Therefore, unless it gets registered with the registrar of companies, it won't get any physical existence and barred from entering into contract with third parties. So not binding on the company means company in its own dignity, in its own name, it cannot enter into contracts with the other parties. It can't use its name while entering into contracts. And the second point says that not binding on third party. See, promoters, if enter into contracts with the third parties in the name of company, that contract is not valid. That contract becomes void. And if they enter into contract, if the contract is successful and both the parties involved in the contract deliver the obligations, give the fulfillments, do it willingly, do the subject matter willingly, then no problem arises. Say for example, I want to sell my land to you for 30 lakhs, you are going to purchase my land for 30 lakhs. So if me and you, both the parties discharge our obligations for 30 lakhs, if I sell the land, against land, if you give me 30 lakhs, the contract gets over, nothing will happen. Problem arises when either party goes to the court against the opposite one. So if something wrong happens, case will be filed and put before the House of Lords. So in this situation, the question arises whether the company is registered or not. So during pre-incorporation period, if the company enters into contract with the third parties, it will be void. Means in the name of company, promoters cannot enter into contracts, or the company itself cannot enter into contracts with the third party. If something damage or if loss happens, if loss occurs, company will not be held liable. And next one, very interesting thing here is no ratification. See, ratification means cancelling the subject matter or cancelling the parties, cancelling the old contract and forming a new contract with the same parties and with the same subject matter. Again, ratification means cancelling the old contract and forming a new contract in place of that. So continuation of contract is called ratification. Continuation of contract on the basis of new contract is called ratification. Say for example, let me give one fine example for this. There is a minor who is only 10 years old, who enters into contract with another person to sell his property or to do something, okay, or any of the contracts. Here, after he gets a majority, one more contract is to be entered into with the same minor after he attains the age of 18 years. Why? Because the contract with the minor is void. So, again, as and when he attains 18 years age, he again enters into contract with the person who is going to purchase his land and make the contract valid. So, no ratification in the sense here. A company, before its incorporation, if enters into contract, it is definitely barred from entering into contracts. Even if it enters into contract, it cannot be continued by framing a new contract in the place later. Say for example, before the incorporation, if it enters into contract on a particular subject matter with the third party, after its incorporation, it has to if it wants to keep up the old contract, terms and conditions of old contract, it has to form a new contract in the place. So, it is permissible by law only for few subject matters, and generally ratification is not permitted. On the date of contract, the company does not show its physical existence and it cannot ratify the preliminary contract. Here, next one, personal liability. See, personal liability point explains that At the time of formation of the company, if some goods are ordered with the third party, they can supply. Okay, the vendors can supply the goods and take payment from it, from the promoters. Of course, before the incorporation of company, it's the effort of promoters to establish a company, right? Therefore, promoters are personally liable. And if the other party supplies necessary goods, and before payment, if the company goes into liquidation, then the promoters themselves will be held personally liable for the mistake done. Say for example, assume that I am going to start a company XYZ Limited, and we promoters offered seller Mr. A to supply necessary goods to our company. So he supplied all the goods, and there is a payment amount due from us to him of rupees 10 lakhs. As and when we pay 10 lakh against the goods supplied by A, the contract comes to an end. But what happened here is, before making payment, our company went into liquidation. So in this case, who will be held liable? We, the promoters, will be held liable. So the same thing is stated here. Any damage or any loss caused by the contracts, by the pre-incorporation contracts, promoters will be held personally liable. And we are moving on to the next one, incorporation stage. See, in incorporation stage, the company gets registered with the registrar of companies. Okay, as we have studied pre-incorporation stage, it is quite important for us to study pre-incorporation stage and after passing pre-incorporation stage, we are stepping on to registration stage or incorporation stage. Here, it's a stage at which a company is registered with registrar of companies, as I said just now. And it comes forward to fulfill all the conditions laid down in Companies Act with respect to incorporation. And of course, it is the second stage in the formation of a company. And company physically comes into existence when it is registered under Companies Act of 2013. Here, the promoters are the persons who are associated with the company for any lawful purpose may form the company by getting it registered with the registrar of companies. Once the company gets registered with the registrar of companies, lawfully means the permission is available from law to perform business operations. So it will get a power, it will get a special dignity to enter into, it will get a special power to enter into contract in its own dignities. So the promoters must decide the type of company proposed to be incorporated. What type of company they are floating, what type of company they are going to establish, what type of company they are going to incorporate must be stated properly. Under Companies Act of 2013, only two types of companies can be registered, mind it, public companies and private companies. Private companies means including one person company. Here, the company formed under the provisions of Companies Act of 2013, whether a private company or public company, may be one among the following two types. One is namely unlimited, following two types, namely a limited company or unlimited company. Means the company formed by the promoters, whether a public company or private company, may of any of the two types, limited company or unlimited company. If it is limited company, limited by share, company is limited by shares or company is limited by guarantee. So this is about incorporation stage. And let me move forward to explain the procedure for incorporation. See, Companies Act of 2013 also continued to say the procedure for the registration or incorporation. First one is application to the registrar for availability of name. Here, application for the availability of proposed name should be made to the registrar in the prescribed form. Means for that also separate form is available. In the prescribed form there is a mentioned form, and through that, in that form only we need to go through to fix the name of a proposed company. So first of all, conceptually you develop a company. Later the time comes to fix the name for it, and while fixing name also at your wish you can't fix. So there is a well framed procedure. The registrar shall then inform about the availability of a proposed name. So he goes through the format given, he goes through the application given for the fixation of a name fixed by promoters, and if it is okay, he will give permission. Thereafter, the company will get registered by filing an application with the registrar of companies. The area where the registered office of the company is situated. It is very important for all companies to fix the name as well as to fix the registered office of the company. Such an application filed by promoters and must be accomplished by requisite fees and documents. So all the procedures, all the paper documents and all the formalities must be supplemented by fees, respective fees. Respective fees will be fixed for every document. So after paying fees, these things should be done. ಇಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಟು ದ ರಿಜಿಸ್ಟ್ರಾರ್ ಫಾರ್ ಅವೈಲಬಿಲಿಟಿ ಆಫ್ ನೇಮ್ ಅಂತಂದರೆ, ಕಂಪನಿಯನ್ನು ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡುವಾಗಲೇ ಪ್ರಮೋಟರ್ಸು ಒಂದು ನೇಮನ್ನು ಫಿಕ್ಸ್ ಮಾಡಿರ್ತಾರೆ. ಆ ನೇಮನ್ನು ಫಿಕ್ಸ್ ಮಾಡುವಾಗ ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್ ಆದಂಥ ಅಪ್ಲಿಕೇಶನನ್ನು ಫಿಲ್ ಮಾಡೋದ್ರ ಮೂಲಕ ರಿಜಿಸ್ಟ್ರಾರಿಗೆ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು. ರಿಜಿಸ್ಟ್ರಾರಿಗೆ ಆ ನೇಮ್ ಓಕೆ ಆದರೆ ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್ ಫೀಸನ್ನು ಪೇಮೆಂಟ್ ಮಾಡಿ ಆ ನೇಮನ್ನು ಫಿಕ್ಸ್ ಮಾಡುವಂಥದ್ದು. ಇನ್ನೂ ಒಂದು ರಿಜಿಸ್ಟರ್ಡ್ ಆಫೀಸ್ ಆಫ್ ದ ಕಂಪನಿ ಎಲ್ಲಿ ಅಂತ ಹೇಳುವಂಥದ್ದನ್ನು ಕ್ಲಿಯರಾಗಿ ಮೆನ್ಷನ್ ಮಾಡಿರಬೇಕು. ಆ್ಯಂಡ್ ಸೆಕೆಂಡ್ ಒನ್, ಫೈಲಿಂಗ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆ್ಯಂಡ್ ಇನ್ಫಾರ್ಮೇಷನ್ ವಿತ್ ದ ರಿಜಿಸ್ಟ್ರಾರ್. So what are the documents we need to file with the registrar at the time of incorporation? You see, now we are discussing about incorporation stage. Okay, so the second one is producing of documents. According to section 7, the following documents are to be submitted. Here we need to submit the documents even after getting the approval of the name. Okay, once you get the approval by the registrar of companies for the use of name prescribed, for the use of name applied for, the application for the registration of company should be filed with the registrar along with the following documents. Once the name is approved by the registrar, these documents, they can go ahead to produce these documents. First one is Memorandum of Association. See, this is a document which describes the scope of company activities, the radius of company activities and boundary of company activities. It must be signed by the required number of persons which are necessary for the formation of company. Say for example, the total number of members prescribed for each type of company. For public company it is 7, for private company it is 2. If it is a private company, only 2 members are sufficient to put signature in Memorandum of Association. So, the total number of members for a private company is 200 and for public company it is unlimited. So the necessary number of members for the formation of company as prescribed in the law must be followed while fixing the members for the company, and the members are so fixed must put their signature. And second one is articles of association. See, this is a document which contains the rules and regulations of the company. It must be signed by all persons who sign the memorandum of association, means the members, according to section 7 subsection 1a. And the third one is prescribed declaration. A declaration in the prescribed form stating that all the requirements of Companies Act 2013 rules made thereunder in respect of registration have been complied with should be submitted with the registrar. According to section 7 subsection 1 subsection b, the declaration should be submitted. Means, see, while applying for the job, or while applying in the college for any of the classes, so declaration form will be given. At the best of my knowledge, the above provided information is correct. So that is, and you put your signature under that, right? At the bottom part, you will put your signature. So this is a declaration form. Okay, after all procedures, you will be given with the declaration form. You need to sign on it. Here, this declaration should be given by an advocate, a chartered accountant, a cost accountant, or a company secretary in practice, who must be in practice and who is engaged in the formation of the company. So, permission is not available for all members to sign the declaration form. Rather, the eligibility goes only to an advocate, or to a chartered accountant, or a cost accountant, or a company secretary who is involving in the formation of the company, or a person named in the articles as director or manager or secretary of the company. So only to these prescribed parties putting signature in the declaration form is available. And next one is affidavit of subscribers and first directors. See, who are all the subscribers should be affidavit. An affidavit from each subscriber to memorandum and from first directors named in articles to the effect that they are not convinced and have not been found guilty of any fraud, misfeasance, or breach of duty under this act, or under any of the previous company laws during last 5 years, and all the documents filed with the registrar are correct and complete. So the subscribers of memorandum, or the members, again I am explaining the same point. Again, the memorandum of, here affidavit of subscribers means the persons who are eligible to put signature on the affidavit form, and first directors should be mentioned. So the persons who have subscribed for the memorandum and form the first directors named in the articles of association. Directors must be named in the articles of association. Those people should not be found guilty of any fraud or breach of contract during last 5 years as per the law. And all the documents submitted by them are correct. So this is the case. And next one, correspondence address. Of course, for mailing or for sending letters, address of the registered office must be given according to section 7 subsection 1 subsection d. Needless to explain it well. So you can understand it well, needless to explain it further. Next one, particulars of subscribers. Here, the complete particulars of name including surname, family name, residential address, nationality should be given in a prescribed form given for subscribing the memorandum of association. And their proof of identity also should be submitted. Section 7, subsection 1, subsection E. And particulars of first directors. See, it will be said in the articles of association. Okay. The complete particulars of name, address, is residential address. So whatever the points we have discussed in particulars of subscribers, the same should be submitted by the first director also, who is named in the articles of association. So here, identity number should also be given by the first director according to section 7, subsection 1, subsection F. And consent to act as directors and particulars of interest. See, by force he should not act as the director, rather he should show his consent in a written form to continue as the director, to become the director of the company according to section 7, subsection 1, subsection G. And next one is registration by the registrar. When the application for registration of the company along with the requisite fee and above document is presented to the registrar for registration, the registrar shall satisfy himself regarding the compliance of legal formalities. So, if he is okay with the above mentioned formalities, then the company is proposed to be formed for lawful object. The memorandum of association has been signed by a requisite number of persons, and memorandum of association and articles of association are prepared according to the provisions of Companies Act. Do not against the provisions of Companies Act. Means these are some of the legal issues should be overlooked by the registrar. What are the legal issues? First one is the proposed company is formed lawfully, or proposed company is having lawful object. The purpose behind the establishment of company is lawful. Second one, memorandum of association signed by the proper number of signed by proper number of persons, properly applicable number of persons. If it is a public company, it is 7. If it is a private company, it is 2. And memorandum of association and article of association are prepared according to the provisions of Companies Act and not against the provisions. Next one, prescribed declaration, affidavits and other particulars have been duly signed and filed. All the above said documents are duly signed and filed. And next one, the name of the company is acceptable. Means the name so fixed. In the previous point we have sufficiently studied, right? Name fixed by the promoter should be submitted in a written form with the registrar of companies. So he goes through it, and if it is okay for him, if it is legally okay, then he will permit the promoters to fix that particular name. So the same is stated here. It is also one of the legal issues. And if the name is okay for registrar of companies, if the name should be neither, if the name is neither prohibited nor as same as any existing company, then it will be made okay. Okay. So if all the above points are satisfied, the registrar of the company, after going through all documents and place of registered office of the company and name of the company, he will register and add the company to the list of register of companies. Okay, so register of companies will be maintained by registrar of companies according to section 7 subsection 2. All if it goes through all the legal formalities mentioned in the registration of companies and registered office of the company and name of the company is okayed by registrar, then the company gets a place, gets housed in the register of companies. And next one is issue of certificate of incorporation. Here, after registration, the registrar issues certificate of incorporation. Means it's a document for the incorporation where he mentions corporate identity number and maintenance and preservation of documents is also related to it. Corporate identity number here, before discussing that, certificate of incorporation is issued for the formation in a prescribed form. It is very important for the company, and it's a legal document proving the existence of the company, and the company comes into existence really according to section 7 subsection 2. So these are the following points which are very important to note in this regard. Corporate identity number, in short it is CIN. From the date of mentioned certificate of incorporation, the registrar shall allot CIN number to the company. On the date of incorporation, if all the legal formalities are prescribed, legal formalities are complied with by the company, he will issue permission for the incorporation, as well as he will give corporate identity number, and the corporate identity number shall be a distinct entity for the company. It gives a separate entity for the company. It shall also be included in the certificate of incorporation according to section 7 subsection 3. And maintenance and preservation of documents is the next one. The company shall maintain and preserve at its registered office the company's all documents relating to the company, relating to the incorporation, and all the necessary documents and information, and all the original files should be maintained, and the files are submitted with the registrar for registration till its dissolution. Means all the important necessary documents used till incorporation should be maintained in a hard copy in the registered office according to section 7 subsection 4. Hope you understood. Thank you.